Thank you all for joining. The idea for today is to share a bit of what we know, what we don't know about the memo implications, and this is going to be based out of a few factors. The first one is, of course, the memo itself, but also then further communication from DHS and the government in general. And lastly, chatter from the attorney community, things we've talked with many attorneys in the community. So, of what they have been seeing, have receiving, what happened in interviews and other things. So hopefully this is helpful. And of course, please feel free to send questions over the chat. And while we do the presentation, we'll try to answer as much as we can. Be patient. Maybe we'll answer a bit more towards the end of the webinar. So let me share a bit the presentation, and I'll give it to Dobrina. So just a quick introduction on us. We're Tukki. We're a U.S. immigration service company. Dobrina here is our lead immigration attorney. She has been practicing immigration for the last 15 years, really focused on business immigration, from extraordinary H-1B to everything else. And we do webinars like this very often when there's these changes, just to help a bit on providing some clarity. So hopefully you enjoy the session. Okay, so Dobrina, I'll leave it to you.
All right, thank you so much, and I apologize. I won't be on camera. I saw a lot of familiar names, so you know how I look. So that shouldn't be an issue that I'm off camera today. Anyway, so today we're gonna cover that's the agenda. Basically, kind of talk about the memo a little bit, and who does it affect? Why are we pushing back? What are people saying in the community? And of course, like it was predicted, the DHS walked it back a little bit. What changed? What didn't change? And some practical tips for applicants, especially applicants who are about to file for adjustment of status. And also applicants who are actually already filed and kind of wondering, like, what's going to happen to their application? How is that green card application going to be adjudicated? So hopefully there will be, some tips and some valuable information so that you can sleep at ease at night. So next slide. So, what is the AOS policy memo? So that came down on, as you probably all know, May 21st. It was a Friday, of course, before a long weekend. They always do that when nobody is paying attention. And basically, what the memo said is that the adjustment of status, or AOS, is actually extraordinary relief. And basically that they're telling applicants who are about to file their adjustment of status to go outside the United States and do consular processing. So pretty much that was the summary of the memo. Of course, it raised a lot of questions. We still have questions on some of these things. But what it really did is, created panic, and also kind of showed us the intent or what they're trying to do, at least internally within USCIS. So why is that? Why is that important? How is that impacting? And why are they doing it? A lot of questions. We don't have answers to everything, but I just wanted to mention a couple things. So when you file an adjustment of status in the United States, whether it's through family, whether it's through employment-based a petition, you will be invited for an interview at the USCIS office. For family-based applications, almost certain that you will be invited for an interview. Employment-based, you may or you may not, depending on the office. And in the United States, when you go for your adjustment of status interview, you have the right to consult. So you have the right to bring your attorney. Some people do, some don't, but it's there. Especially if you have, something in your case that is of concern, prior immigration violations and other things. So people do, do go with an attorney. You don't have that when you do consular processing. There's no right to an attorney, so you go by yourself. That can create issues because obviously you don't have that, second eye and second ear during the interview. They can say whatever, you have no proof that what they said. So that's one concerning factor. The other thing about consular processing is that it's basically if your case gets denied, you cannot appeal, you cannot sue for the most part. So that decision is final. Versus adjustment of status, obviously, if it's get denied, you can appeal. Maybe you can file a lawsuit depending on the denial. You have way more options versus, sitting outside the United States and just trying to reapply, I suppose. So it's very important to remember the consequences of doing consular processing and why they're doing these things. Um, to be honest, I don't know if that's what they thought when they put this thing together, but that's the result. And of course, conveniently, they didn't mention this case in the memo, matter of array, where basically it says that AOS should be approved absent adverse factors. No need to document equities. And also, the word on the street about the memo is that it actually they didn't give it to their legal. Nobody from the legal at USCIS actually reviewed the memo. It was just sort of like shared with everybody. And basically, the USCIS policy manual says that absent compelling negative factors, officers should exercise favorable discretion. So there is there is a conflict already between what the policy manual says, what the case law, established case law. I mean, this is from 1970. Most of you or us were not even born. And then we have this memo that is in total contradiction. So, I mean, we already have issues here. Next. So who does this memo affect? Well, so I kind of split and sort of like higher scrutiny, and at least this is our interpretation, and obviously speaking with other attorneys. I think they were that memo in particular targeted people who come on B2, which is the tourist visa, and 2 months later decide to file a green card application through marriage. So this is one group that really, really needs to be careful because the memo targets that segment. Also, we have non-immigrant single intent visas, where it's like the TN is a non-immigrant, the E2 is a non-immigrant, the E3 H-1B1. So if you are on these types of visas and you file for adjustment of status, I would be careful. You might be better off requesting consular processing on the application, and then depending on where we stand with the memo, then we go and see what it needs to be done there. But I think the target group was people again on B2, people F-1 as well, where you come in as a student and 3 months later you apply for adjustment of status. So those will be highly scrutinized. And I would not. I mean, definitely, you need to talk to counsel and see how what is the best option for you. So we are monitoring closely the H-1B L1. Those are dual intent holders, meaning that you can have the intent to file for a green card or not. That's why it's a dual intent. O1 is also dual intent. I know some of you on the call are on O1. So O1, it's kind of I mean, it is a dual intent. It's in the FAM, it's in the policy manual. So technically, this should be okay. However, the reason it's, monitored closely is because they had I forget on what page on the memo, there was a footnote saying that just because you're an H-1B on L1, that it, doesn't mean that you're exempt or something like that. So obviously they did not acknowledge the dual intent situations. I don't know whether they didn't acknowledge because they didn't know or because it was just like an oversight or they really don't care. So I don't know. But it's a footnote there. So that's why we monitor closely. And obviously the EB5 investors and concurrent filers. So if you're an EB5 investor and if you're investing, in north of $800,000, obviously there are considerations there in terms of the economic impact that you provide that the memo talks about. So that's why it's closely monitored and generally protective or, immediate relatives of U.S. citizens, clean record, no violations, and 245I protected applicants. You don't really need to know about that. But what probably concerns you is the higher scrutiny and what's monitored closely and from these segments. Next. So why experts are challenging the memo? Well, many reasons. Number one, we have this binding precedent from 1970. It's really old, where they already overturned the extraordinary relief label. So the memo said that they can only you can only apply and they can only grant the adjustment of status in as extraordinary relief. That's not in the regulation. I mean, obviously, it has been overturned since the 1970s. Statutory mismatch, again, the 245 does not use the word extraordinary. The memo investor standard Congress didn't write, so that's a problem. Obviously, APA violation, changing established USCIS policy manual standards requires notice and common rulemaking. So that's if they wanted to change how they give how people apply for adjustment of status and, who gets the adjustment of status and who should apply for adjustment of status, they had to actually go through the rulemaking process, which takes forever. I mean, not forever, but, it could take, more than a year. And obviously it's going to get into, litigation because it's just, so unlawful. And then obviously they ignored what I mentioned, the dual intent. So Congress gave H-1B L1 holders dual intent rights in 1990. As you see, these things have been established for some time now. I mean, this is not something that, was done in the last 5 years. And also due process. I mean, nationals of, we have 78 or so countries that are travel banned from consular processing. So, you can apply for AOS, but you cannot do consular processing. So now they want to send all of these people consular processing, but then they're banned. So they're going to get stuck. So these are some of the things that potentially, if there is a lawsuit, and there probably will be, obviously the courts will be looking at. And that's why we think that memo is it's not gonna stand for very long. And of course, the DHS, they walked back. It's a well-established DHS tradition to drop something on a Friday before a holiday and then walk it back the following week. And that's what happened. I think a lot of people, especially folks that are like on H-1B, L1, O1, and have been here in the United States for forever. Now, you're told, oh, you have to go and, you cannot apply for adjustment of status. You have to go outside the United States. So they walked it back. I mean, it reported in the New York Times that allegedly the memo was just a reminder to officers of their discretionary authority, which has always existed on case-by-case basis. So this is true. I mean, any immigration benefit for the most part, it is discretionary, especially, getting a green card, applying for citizenship. They've always looked into positive factors, negative factors, but then, what is positive factor? What is a negative factor, right? So they kind of walk that back. They also confirmed that immigrants would not automatically be required to leave the United States because some people assume that, okay, I have to pack and go. No. They also said no blanket policy change. Individual officer decide on case by case basis whether an applicant must go abroad. So this kind of gives, I mean, the officer that you're talking to during the interview, or if there's no interview officer looking at your documents, a lot of power basically. That they I mean, they always had discretion, but now it's kind of like, if they don't like one thing in your case, they'll be like, okay, I mean, I cannot approve you today, under this memo, you should go consular processing. um so that's where we are. That's why even within USCIS offices, from what we see, like during interviews, some offices are implementing the memo and some are not implementing the memo at all. And some are totally ignoring it because they don't know what to do with it. So yeah. So non-dual intent holder remains again a higher risk. That would be your, TN, E3, F1, OPT, and J1 visa holders. So again, we think that the memos especially targets this group. If you are in one of these visas or statuses and you're planning to adjust status, please don't do it yourself. Talk to an attorney so that at least you know the risks. Okay. Again, I'm not saying that they will deny your adjustment of status if you file on OPT and F1 OPT and E3 or TN, but you have to know the risks because those are the non-immigrant visas. Now, what we have seen, if you go for an interview, there are new interview questions, or they're already being asked. And I think, the questions on the next slide, but or the following. Basically, either they ask you during yes, so here are the questions. In addition to everything else that they ask, about your application, they will, these are some of the questions our colleagues have shared. Why did you apply for adjustment of status instead of consular processing? Are there any factors preventing you from consular processing? Why did you not leave after your period of authorized stay expired? So this question is for the folks that, came on, like B1, B2, or F1, or some type of visa, and then their status expired, and ultimately they married a US citizen, and now they can adjust. So that applies to them for the most part. And then what was your intent when you came to the US with your visa? So this, obviously, I mean, I cannot tell you what to answer, to these questions because, each case is individual. But for this particular question, at least to me, what they're looking at here is inconsistencies. So, what did you tell the consular officer, when you went for your B1, B2 interview, when they ask you, why are you going to the US? What did you tell the CBP at the time of entry to the US? And then what are you gonna say at the time during your adjustment of status interview? So obviously you have to be consistent. So if you told the consular officer that you wanna go to Yellowstone and Disneyland and like basically do tourism in the United States, and then you told the CBP at the time of entry that, you're gonna do all of these touristy things. You come in and then you apply for adjustment of status because you magically got married like the first couple months. We have a problem. So, and these are the types of cases that, that memo probably targets. And then obviously, on the last question, do you have any family still living in the home country? So these questions are being asked during adjustment of status interviews, whether it's family-based or employment-based right now. If you're not invited for an interview, attorneys are sharing RFEs that you can get an RFE with these questions, and then obviously you have to address that in an RFE and submit, submit back to the service center or field office that is processing your case. Now, of course, if your case is already pending, what happens if you filed before this memo? Well, that's an technically, legally speaking, you should be grandfathered, meaning that the memo shouldn't apply to you, so they should not ask these questions. But from what we see from, the interviews that are going on right now, those are cases that have been submitted before the memo. And as I said, some of the USCIS offices are either not following the memo with officers saying that you're approvable, but the case needs to be on hold until they figure out what they're gonna do. So that's kind of where we are. Practical tips protecting your green card application. Of course, read the actual proclamation, not just the headlines. I mean, I remember the headlines like on Friday. The first thing I saw is like, the green card process is dead. Well, that's not exactly what the memo says. So don't go after, headlines or breaking or whatever. Nothing is breaking as of right now. Your specific country visa and status date also matter, so it's not just one thing. If you're outside the United States and your country is on the ban list, obviously you do have, additional hurdles there. Do not leave the United States just to test how this is gonna work. Again, if you fall into one of those H-1B, L-1, O-1 categories, you can adjust in the United States. I wouldn't be afraid to do that, but obviously, it has to be, done the right way. And yeah, only travel internationally if necessary. We just don't know what's gonna be the next memo coming up, next Friday or what's the next holiday, July 4th. So they like to do these things on short notice. And document your equities proactively, like employment letters, tax returns, family ties, community involvement in the United States. So those are the types of things that they might want to look at, under that sort of discretionary test. Obviously, if you have any immigration issues or had immigration issues or any criminal issues, even if you're on H1B or L1 or O1, that might be problematic because those will be considered negative factors. And while, before the memo, especially if it's something that has been resolved, that wouldn't be an issue. Now with the memo, we have to be a little bit more sensitive because, if you have any negative factors, in your immigration history, that has to be reviewed pretty closely and just to see like, what makes sense for you at this time. And of course, this is not too well known, but this is the only protection that we have under the employment basis. Think of like a waiver, the 245K. So of course the memo doesn't talk about. I would be shocked if they actually know what that is. But so under this, if you have any status violations or specifically, I mean, this is for employment based, under 180 days. Let's say you worked without authorization. Like I had one client in the past, she worked without authorization because the EAD expired. She continued working, or there's some unlawful presence for whatever reason, your petition didn't make it to USCIS on time or got rejected. If it's under 120 days, you're protected under the 245K, so technically kind of waives the violation. So you should be fine. And of course, if you're concerned or if you have any of these things going on, now it's the time to talk to your attorney, about your situation, what makes sense at this point. My prediction is, by the time, so let's say you file your adjustment of status now. By the time they get to your case, the memo is either going to be dead, watered down, or non-existent. So it's just we'll just have to see, like, when are we gonna have the first lawsuit, and obviously how far USCIS will go with this. So travel and entry, what the proclamation does and doesn't do. So the obviously, again, I'll focus on the does not do because those are more important. Again, there were a lot of headlines saying like, okay, you're banned from the United States, you cannot apply, the adjustment of status is dead, all kinds of things, and that it's gonna strip of your green card. I mean, you're gonna lose your green card if you're already a green card holder. So that's, I mean, obviously that's not the case. So it also doesn't validate your visa. Some people like, well, like maybe they will revoke my visa now, and just a lot of speculations. So it doesn't apply to US citizens. I mean, I saw some of that chatter as well. So if you're naturalized US citizen, and it doesn't affect if you're in valid status inside the United States and if you don't travel. So, I mean, it doesn't really have immediate impact to folks who are here, especially under the employment-based visas, especially that are, dual intent. Now, if it's a non-immigrant intent, I would be, I mean, there's a discussion to be made there, but I wouldn't necessarily worry too much about that. Now, if you are here on a B1, B2, and you apply for adjustment of status right away, or even if you waited, or if you come on B1, B2, and then you're out of status, and then you apply for adjustment of status, that would be an issue. If you're on F1 and you lost the F1, and then you're applying for adjustment of status, that could be an issue as well, because those are the segments they're targeting. And kind of like a key takeaway that, I mean, I already sort of went through all that, but basically it is alarming, yes. But they since confirmed backwalk that it's not a blanket I mean, it's not a blanket requirement to leave the United States. It's case by case. For individual officers, your facts, visa type, and history matter enormously in these cases. Non-dual intents, TN, E3, F1, J1, face the highest risk under this framework. And yeah, build your equity file now, to show that you benefit the United States. Obviously, I mean, the thing is, like, if you file, if you have a EB1 approved under the extraordinary ability or the national interest waiver, I think, I mean, this memo is just like, it's kind of laughable, but nevertheless, don't assume that the officer, if you go for an interview, the officer will know what extraordinary EB1 extraordinary ability is or what national interest waiver is. That's not their job at that level. So you still have to present your equities. Similar, I mean, if you get an RFE, obviously, that's. I just have to respond appropriately. So federal court challenges are very likely to enjoin the memo since, I mean, it's illegal for most part. And of course, every case is different. Everybody has, different situation, different issues, different problems. So don't think that because your friend got approved, you will, or vice versa, because your friend got denied, and you will get denied. That's not necessarily the case since we don't know what your friend has. So that's the end of the presentation. So if there are any questions, I think we can address now.
Yeah, there's a question. What about immediate relatives who entered on B2 and then applied for green card via adjustment?
Yeah, so that's that's a segment of I think the memo is also targeting that. Now, obviously, if you already applied, I mean, that was before the memo, right? So there's nothing you can do except wait for that decision. Now, if you just entered and you apply right away, I mean, I would be concerned a little bit. Again, remember that this will, I mean, by the time it hits your case, or the officer, starts reviewing your case, that it might be, a year from now, 8 months from now. We don't know where that memo is going to be at. But definitely, I would, if somebody were to ask me now, I would suggest consular processing in these specific cases.
Okay. There's a few questions about EB1A. So
Mhm.
if your EB1A gets approved, what happens with the memo applies to you or not?
I mean, I would, assuming that you're on H-1B, let's say, or O1 or L1, I would file for adjustment of status. The only thing is, and I think we've been doing that in Tukki, when you file the I-140, you won't request adjustment of status, you would request consular processing. Um, that doesn't change anything for you. You can still adjust status once you get that I-140 approved. But it shows that you have the intent to consular process. But outside that, I would apply. I wouldn't necessarily be too concerned about the memo.
There's another question. How about H4?
H4 is dual intent, so I think that should be, I mean, again, I wouldn't be concerned with that as well.
Yeah, especially if it's with H1B, right? Yeah,
Yeah, especially if it's with the H-1B.
yeah. If it's to H1B1.
Yeah, and then the memo talks about like, oh, and I think they walk that back as well a little bit, say, oh, wait, yeah, if you like show that, you have a economic impact to the US and all that, although they didn't define what that is. Because the thing is, okay, you're on E2. If you're on E2, that's an investor visa, but it's a non-immigrant, right? So it's a single intent non-immigrant. But you have an economic impact, especially if your business is doing well, if you're hiring US employees, and if the business is growing, and then you apply for adjustment of status from E2, it's a non-immigrant, but you have an economic impact. What happens there? I don't think they've gotten that far. Like, I mean, to
Yeah.
analyze these situations.
There's another similar. What if you're on F1 and your EB1 is approved?
I mean, I think I think one we have to look at, how long have you been on F1? Is it been like, 1 month, 1 year, 10 years, 2 years, 5 years? Also, you can also always mark consular processing on your I-140. And then I would still, to be honest, depending on, how long you've been in the United States, I would apply for adjustment.
Okay. There's another F visa question. So for F1 visas, is being an F1 risk the risk, or if the risk is if you were in F1 in the US longer than you were allowed to? If you have been following the dates, should we be okay? I am about to be on F1 STEM OPT.
Yeah, I mean, I think it doesn't matter how long you've been in the United States. Again, I wouldn't be too concerned.
Okay. Would this impact immediate relatives of US citizens, spouses who already received the conditional 2-year green card and will
No,
apply for the 10-year green card?
no.
Okay.
I mean, can they question? Can they ask you these five magic questions? Sure, but I don't think that that's. I mean, you're already way. I mean, way after the.
Yeah, you
Way
already have a
past
green
that
card. Yeah,
stage.
yeah.
Yeah, yeah.
Since you mentioned it's on a case by case basis, does that mean if an applicant needs to leave the country, USCIS will specifically ask the applicant to leave the country?
Mm, I mean, what do you mean? They're not gonna ask you to leave. They're just deny the case,
So
and
if
then
they deny the case, technically
yeah.
you are without except you have an underlying.
hmm
Uh,
Yeah, yeah. So that's the thing. You have to make sure, especially for the folks on H-1B, L-1, the O-1, J-1, you have to make sure you keep an underlying status. So don't give up your status. Don't, I mean, if possible, don't go and just work on the EAD. Because if something were to happen, like let's say you get denied, you can still be on your H-1 and then you can do consular processing. So you just have to book an, trip. So doesn't, I mean, things don't change dramatically except that you just have to go consular processing.
yeah. Okay. Question on mass social media advertising about AV2 and IW. I was dropped by a lawyer halfway through preparation over their concern that 70% of petitions were being rejected. Now the same profile either gets enthusiastic responses or clear rejections from firms. Any suggestion on how to screen firms?
Um, yeah, I mean, the thing is, if it sounds too good to be true, probably. Yes, NIW also, I mean, NIW in particular, it's not doing too well with approval rates. So anybody that tells you this is the best option out there for you, it's probably not honest unless you have some amazing case. But the approval rate for NAW right now is what, 30%?
36, yeah, something.
36, something like that, which is a historic low. So if people are telling you, oh, this is the best option, this is what you have to do, everybody is doing it, I would be concerned with that statement. I mean, yeah, people might be doing it, but we have the results are not that great. I guess in terms of screening, I mean, you can ask like, the types of profiles that they have been successful with, and whether yours is kind of aligned with one of those profiles. Of course, I mean, they can tell you anything they want, but generally, yeah, if somebody is kind of painting, too rosy of a picture, I would be concerned.
Okay, thank you. What would you recommend for someone in the US at the end of their F1 OPT on F1 for over 6 years who is from one of the banned countries? Would you recommend remaining in the US and filing AOS?
I mean, again, I have to look at your F1 history and what's going on there. But yeah, I would.
But also, if it's banned countries, I don't know if you have an option, right? Because some of these banned countries they are
Yeah,
not issuing
some are
consular.
banned also from. I mean, you can file with USCIS, but they'll just get the application and it's just gonna be. They're not gonna process it.
Yeah, but also, and some of them, the only thing they do is that they process AOS, but they don't process consular processing at all. So in
Yeah,
that
yeah.
there are like three groups of banned countries.
Mhm,
So it's depending on which one of those. Like it's not just one ban. There's like three bans with different implications.
mhm.
What level of community support consider as positive factors?
I mean, anything I would say, if you volunteer at the homeless shelter, I mean, anything that kind of puts you in a positive light, that would be positive factor for you. Also within your own, with your own profession, do you volunteer at things? Do you, I don't know, do you mentor students? Things where, they would be sympathetic to the officer.
Okay. What if you had already applied for an EB1A pre-memo and are already on a pending AOS, currently in parolee status? And what if my wife was F1 and is a dependent on my EB1A case? And by the way, my wife was on F1 for 3 months when we applied for the AOS.
Mm, I wouldn't be she's the dependent. I wouldn't be too concerned at this
Yeah.
point.
Yep. Okay, and I think the last one we have is if I enter the US on in an F-1 and then change to H-1B before filing the 485, can I apply for AOS?
Yeah.
Okay, great. Any other questions? Anyone that you want answered? Okay, cool. Well, this bring us, okay, I think one more. Okay, is it okay to travel domestically via plane if B2 is still valid but stay longer than 6 months and apply for a green card? I mean, if it's valid but stay, well, I think we should check the B2 and how whether
Yeah.
if it's valid or not.
Yeah. Yeah. I mean,
Yeah.
in the past, I would say traveling domestically was fine, but obviously now they have some enforcement and ICE and whatnot around the airports, and that it depends on where you're in the process, and yeah, I would be you would want to check that.
Yeah. And the last one is what was the approval rate of NIW before? I think in the best moment, closer to 2022, at one point it was like
Yeah,
86%.
it was really high.
Yeah, it was really, really high. I think probably a lot of
Probably
consul.
that's why we see
Yeah.
the results now.
Yeah,
Like,
probably too high, with some cases getting approved, which were very interesting. But yeah, now it's definitely low. And that also, by the way, is happening with EV1A. So
yeah.
EV1A, when you look at the last 3, 4, 5 years, it's always remained consistently between 65 and 75, 72. And the last thing was a bit even below 50. So that has never happened, at least in the recent history. So there's definitely a very hostile adjudication scenario, and even with very like ridiculous RFEs or denials. So that there's definitely a hostile environment, and I think it's good to plan for that and be ready for to deal with those type of responses.
I think the cases, I mean, both for NAW and to some extent EB1, they're probably doing slightly better. Are usually, I mean, the researchers, postdocs, PhDs. I mean, obviously you have to like meet the requirements, but these are doing slightly better. Versus the NAW, if you're like an industry profile, that would be tough.
Yeah, that's very yeah, that's very tough. And also I think in EV1A we're seeing better adjudications for non-industry professionals these days, like the what are we now saying, like the researchers or even artists, like non-industry professionals, I think, at least
Non-tech.
yeah, non-tech. Like in our practice, we've seen less pushback on those profiles, and we've seen more pushback on like tech profiles and industry profiles.
Yeah.
Okay. Well, hopefully this helped a bit on the situation, on the where we are. And of course, we'll keep you posted. We'll monitor this closely and see what's happening out there and potential lawsuits or not. And we'll definitely keep you updated with anything new we see. So thank you very much for attending, and hopefully we'll see you on the next one.
Thank you, guys. Bye bye.
Thank you. Bye.